All right, if you're a legal professional or hoping to be one, and you're diving into the world of alternative dispute resolution, or ADR, you know that the little details are everything. The right word, the right term, it can make or break your case. So think of this as your personal study guide. We're going to break down who's who, what's what, and the kind of precise language that really separates the pros from the newcomers in the world of ADR.
Okay, let's jump right in with a question that trips up a surprising number of people. Arbitrator versus arbiter. They sound so similar, right? But in a legal setting, using the wrong one is a dead giveaway you're not an insider. We're going to get to the bottom of this very soon, but keep that question in your head. It's the perfect example of the kind of precision we're talking about today. So here's how we're going to tackle this. First, we'll meet the main players on the field. Then, we'll check out the major institutions that set the rules of the game. After that, we're going deep into the specialized vocabulary of the arbitral tribunal itself. Then we'll switch gears to the grammar you need to build a killer argument, and we'll wrap it all up by listening to how these professionals actually sound in the real world.
Okay, Section 1, ADR's key players. First things first. Before we get lost in the weeds of procedure and legal speak, we've got to be crystal clear on who's actually involved. These are the three fundamental roles you're going to see in pretty much any ADR situation.
First up, the negotiator. And here's the most important thing to remember. A negotiator is not neutral. Not at all. They are there for one side and one side only, their client. They are an advocate. You know, think of a lawyer for a tech company in a patent dispute. Their entire job is to push for their company's best interests, trying to reach a deal before it ever has to go to court.
Next, we have the mediator. And the magic word here is facilitates. A mediator is like a neutral guide for the conversation. They don't make decisions, they don't pick sides, they just help the two parties talk to each other and, hopefully, find some common ground. So in a messy business divorce, a mediator isn't going to say who's right or wrong, they're just going to help the partners figure out a way to split things up that they can both live with.
And that brings us to the arbitrator. Now this is where the power is. An arbitrator is basically a private judge. They hear all the evidence, they listen to all the arguments, and then they issue a final decision. And here's the key. That decision, which is called an award, is legally binding. You can take it to a court and have it enforced. It's a very serious role.
So, let's go back to that question from the beginning. Arbitrator versus arbiter. Here's the deal. An arbitrator is a formal legal role specific to ADR who issues binding awards. Simple as that. An arbiter, on the other hand, is a super broad informal term. Your friend who settles a debate over pizza toppings could be called an arbiter of taste. Their ruling has zero legal weight. So the bottom line for you? In any legal context, the word is always arbitrator. All right, so we've met the players. Now, where do they play? Well, major international arbitrations don't just happen out of thin air. They're run by big, powerful institutions that provide the entire framework, the rules, the procedures, and all the support needed to resolve these massive disputes.
And these are the heavy hitters. You've got the ICC in Paris, which is famous for being incredibly hands-on with its cases. The LCIA in London is one of the oldest, a real blue-chip institution. The AAA is the big one in the United States, and over in Asia, the giants are CASAC in Singapore and HKIAC in Hong Kong, which is hugely important for any disputes involving China. Trust me, the choice of institution is a major strategic decision.
Okay, we know the players and we know the arenas. Now let's really zoom in and go inside the arbitral tribunal. Getting this next set of vocabulary down is what truly makes you sound like an insider. This is the language of the inner circle.
So in a big case, you'll usually have a panel of 3 arbitrators. Well, someone has to be in charge, right? That's the presiding arbitrator, who's also often just called the chair. Think of them as the chief of the tribunal. They run the show, set the deadlines, and, critically, if the other 2 arbitrators can't agree, the chair often has the tie-breaking vote.
Now here's a term that trips people up all the time. In arbitration, when we talk about the tribunal, we are not talking about a courtroom or a building. The arbitral tribunal is the group of arbitrators themselves. It's the decision-making body, whether it's just one person or a panel of 3.
Okay, this is a really fascinating role you won't find anywhere else. The institutional counsel is a lawyer who works for the institution, like the ICC. Their job is quality control. Before that final award goes out the door, they review it with a fine-tooth comb, looking for any tiny errors that could get it challenged in court. They're basically the guardians of the entire process, making sure the final award is bulletproof.
And finally, we have the unsung hero who makes sure the trains run on time, the tribunal secretary. They're the organizational powerhouse behind the scenes. They're handling all the documents, scheduling hearings, managing communications, all the administrative stuff that lets the arbitrators focus on the actual legal questions. It's an absolutely crucial role.
Okay, so we got the people and the key terms down. Now let's talk about the actual language you use to persuade. In legal writing, how you connect your ideas is every bit as important as the ideas themselves. It's all about using your words with precision and power. We're talking about those little words and phrases that build bridges between your points, linking words. These things are not just filler, they are the actual architecture of a strong argument. They signal to the tribunal exactly how your points fit together, creating a logical flow that's easy and, more importantly, persuasive to follow.
So let's just look at two key types. First, you have words of addition, like furthermore or moreover. You use these to stack your evidence. It's like saying, here's my point, and another thing, and another thing. But then you have words of contrast, like however or conversely. These are so powerful. You use them to say, I understand the other side's point, however, here's why it's wrong. It shows the tribunal you've considered all angles, which makes your own argument seem that much stronger.
All right, pop quiz time. Prepositions can be a real minefield in legal English. Let's see how you do. By or for? Number 1, the contract was terminated by mutual agreement. That's the method. 2, the new legislation provides greater protection for consumers. That's the beneficiary. 3, all evidence must be submitted by the end of the business day. That's a deadline. 4, the attorney argued passionately for her client's freedom. That's the purpose. And finally, number 5, the arbitrator's decision is binding by law. That's the authority. So, how'd you do?
Okay, for our final section, let's put it all together. Because it's one thing to know these words, but it's a whole other thing to hear how they're used in a professional context. We're going to do a quick listening exercise to hear how these different players actually sound. First, let's listen in on the presiding arbitrator. Imagine you get this voicemail. Hello, this is Anna, and I'm serving as your presiding arbitrator. My primary duty is to lead the arbitral tribunal and ensure the entire process is conducted fairly and efficiently. I hold the procedural authority to set all timelines. My aim is to deliver a prompt, enforceable resolution based strictly on the facts presented. You hear that, right? The tone is authoritative, procedural, and focused on fairness and efficiency. Okay, now for the tribunal secretary, a totally different feel. Hi, Mike. This is Maria, and I'm assisting the arbitral tribunal as the tribunal secretary for your case. My role is administrative and logistical, designed to keep your proceedings moving smoothly. I handle all filing, manage the hearing calendar. Please direct all scheduling queries and document submissions to me. See the difference? The language is helpful, organized, and totally service-oriented. It's all about making the process run without a hitch.
And finally, the institutional counsel. Good afternoon, my name is Diego. I do not represent either side, but rather the integrity of the process itself. When the arbitral tribunal issues its final decision, my main duty is to scrutinize that award for any formal or technical flaws. This vetting process is absolutely critical to ensuring the award is legally sound and fully enforceable in courts worldwide. The focus here is completely on integrity, quality control, and making sure that final decision is ironclad.
So, we've met the whole cast of characters and learned to speak their language. We've gone inside the world of the arbitral tribunal, which brings us to the final, most important question, the one for you. As you think about your own professional future, which of these roles feels right? Are you the advocate, the facilitator, the private judge, the organizer, or the quality controller? Figuring that out is the next step on your journey in the world of ADR.